Okay, we've got something very serious to talk about, and that is the crazy amount of misinformation in the crypto space. More specifically, the SEC filed for an appeal in the Ripple versus SEC lawsuit. When I look at my comments section, there have been tens of people who said, Dusty, don't believe this news. When I tell you something, it's real. I back it up with sources, or I tell you it's a rumor. This actually happened. I'll give you guys an update on exactly what's going on and Ripple's official response to it. But please understand, guys, I do everything I can to make sure you've got the best news in terms of most accurate in the quickest way possible. I think 99% of you guys know it, but still wanted to make that clear. I take this very seriously, and I appreciate every single one of you for stopping by every day. You guys are amazing. Just want you guys to know that. First of all, I loved this. Oh, coming in hot from Ripple. The SEC does not have the right to appeal just yet, which is why they are asking permission to file an interlocutory appeal. Ripple will file its response with the court next week. Stay tuned. So for anybody wondering whether or not this was real, got your answer from Ripple. I should quickly say before I move on, guys, make sure you go ahead and press that like button, as it makes these videos perform just a little bit better, and it doesn't cost you anything. So please press that button. And this is going to be a long video, so I also want to quickly insert here. This whole debacle, this whole issue, is not about XRP itself being a security. The SEC can't allege that. They're not trying that. So please do not worry. XRP is not a security, and that really can't change for as far as we understand, right? Because the issue at hand is not whether or not XRP is not a security. Then again, that's for the future to decide if something really wants to come at it and try it. Right now, the only question at hand is whether or not the SEC should be allowed to file this interlocutory appeal right now. That's the only question. And I noticed I have to explain a couple more pieces. So what the SEC has done here is, before the case is finished, appeal a specific decision the judge made. So to elaborate upon that, the Ripple versus SEC case has been ongoing for 2 and a bit years, right? Since the 22nd of December, 2020. And a judgment was awarded to Ripple on the 13th of July, which basically stated programmatic sales of XRP by Ripple are not securities and things of that nature, but there was still some things which needed to be discussed. All right, this is the official ruling. The court shall issue a separate order setting a trial date and related pre-trial deadlines in due course. The court does not address whether secondary market sales of XRP constitute offers sales of investment contracts, because that would depend on the circumstances, yada yada. And that's again the update we got ourselves a little while ago, where the judge basically wanted to continue on with the lawsuit. Set a couple of different dates. Those were August 23rd. By August 23rd, the parties shall submit blackout dates for trial. By December 4th, the party shall submit any motions in limine. I'm not sure what that means. Opposition to any motions in limine. I'm not sure
Limine.
why it showed me the Italian one. It's Latin, isn't it? Yeah, of course. I'm a human being, right? I share what it means at the threshold. I could cut that out to look smarter, but I'll keep it in. I'm a real guy. Anyway, those shall be submitted by December 18th. And so the whole schedule is basically set right now. For the first pieces, I should explain as well, because the court shall schedule a final pretrial conference date upon setting a date certain for trial. Like, there was a lot more which had to come starting December, basically, because you guys can't perfectly see it, but I'll show you. Judge Torres has issued a pretrial scheduling order saying that the court will seek to schedule a jury trial for the second calendar quarter of 2024. So again, it would take another entire year, basically, and a little bit to get to some sort of conclusion. But then again, slightly afterwards, the SEC came in to say, hey, you know what? We want to make sure that not everything that comes out of that final result, right? Because the trial is to basically end the lawsuit type of debacle. Once the trial is over and done with, the lawsuit is over. Right now, the lawsuit is still ongoing. It's just the summary judgment was awarded to Ripple, right? Ripple won on a lot of pieces. SEC won on some parts. That does not mean the entire lawsuit is over. There was a lot of confusion in that. And so, officially, the SEC cannot appeal until all is done with. But, like I described in my previous video, they had so many different parts and pieces and requests as to why they want to file this earlier. A lot of it is based on the idea that it's going to take them so much time to get information, basically. And they quoted Ripple by saying it all should still probably take a couple years. And they also quoted just how important the case is and how important the actual review again of the decision is to make sure that the different opinions about the law, and they quote some different judges, cannot be misunderstood basically. And for that reason, they can't wait until the entire lawsuit is over to file their appeal, but they've got to have it now, all right? That's again the part of intellectuary, because they want it now before the entire case is over. They want to already appeal a decision the judge has made, even though the case is still ongoing. And that's why it's also such a small chance they actually get rewarded this. Again, they filed for an appeal, meaning they're filing to actually put the appeal in. It's not the appeal themselves. They say, hey, please, judge, let us actually go and basically go against your decision right now. Let's send it to the Appellate Court Commission, I believe. They basically said, hey, let's get this reviewed. Anyway, Meta Lawman said the SEC v. Ripple update. As expected, the SEC has submitted a letter notifying the judge that it will ask her to certify an interlocutory appeal with respect to her rulings in favor of Ripple. Ripple will have 1 week to respond, which again, they've said they will do. I've been reading so many different responses, questions, and answers, and Dr. Giggle said, can the judge simply say no to hearing the appeal? Second Circuit, can they also just say no? And Jeremy said, yeah, that's true. That could be the case. Sherry asked, the bigger takeaway from this is now I have 2 cases to refer to in regards to intellectual appeals. Rio Tinto took 26 days and now Ripple at 28 days. I swear it seems like the SEC aims to be dramatic with these last-minute filings. And Jeremy said that pretrial order lit a little fire under their butts because apparently right after it was filed, they came in hot with the fire. Again, guys, there's so much stuff going around this. Again, take a look at this. Eleanor Tourette says, for a breakdown, make sure you follow Crypto Law US. SEC also requesting a stay of everything else in court, including trial and the pretrial timeline set up by Torres today. Ripple has 1 week to file a response. Let's see this dialogue. They actually waited until she made the pretrial orders to file a motion for leave, to file an intellectual appeal, and to stay the pretrial order she just made. Don't give them the leave. And as far as I understand from the context here, that basically means they are trying to get this all paused, which is something that I didn't know earlier. Moon Lambo asked a couple different questions. When the SEC wrote, the motion will also seek to stay the district court proceedings, including the recently entered scheduling order, right? So that means the judge just put up a scheduling order, make that stay, pause it basically. Does that mean pause the jury trial proceedings? And is there any impact on the Torres decisions regarding XRP programmatic sales? So that last question, the Crypto Law quickly shut down, saying, hey, this trial has nothing to do with Judge Torres's rulings, right? The trial part. She ordered the trial in her July 13th decision to decide the last narrow set of disputed facts related to aiding and abetting allegations against Brad Garlinghouse and Chris Larson. The SEC, are requesting a stay of all other proceedings in the Torres court on the case, meaning remedies process and the trial would pause. Just because they request a stay doesn't mean they'll get it. They might get a temporary stay while their petition for the intellectual appeal is decided on, but that would not be a long one. In any case, if they hadn't asked for a stay, then their arguments for urgency in requesting the intellectual appeal would seem pretty weak. In case you're wondering, a stay has no effect on Torres's ruling. So again, if they, and they did, right? If they said, hey, this has to be done as quickly as possible, because they stated a lot is relying on this. If they didn't say next to it, let's pause all the rest, which again, now it all makes more sense. If they didn't say that, then indeed, you're saying you need a lot of urgency while you're not willing to pause all the rest is pretty weak. Because in theory, right, this should be the most important thing in the world for you if you're filing for an appeal before the case is even over. So if you're then not, so anyway, I should once more say the SEC just filed to get the right to appeal. This is not the official appeal. And the intellectual piece being that they're trying to file it before the case is even over. And they keep saying just how quickly it needs to be done and how intensive it's going to be to basically get to the bottom of everything else. So they want to make sure that it doesn't drag out for years, but they get the review, the new review, as quickly as possible. The way I see it, XRP's got legal clarity and nobody's going to change that. The way I personally see it, the SEC shouldn't even have the right to appeal because at the end of the day, I like this one a lot. They're called, think with me here, they're called the Securities and Exchange Commission, right? XRP is not a security. So get out. They don't even have the right to talk about XRP. It's not even in their little arsenal. At least it shouldn't be. Now, again, I should also yet again add that even if the appeal gets filed, like we saw from Jeremy Hogan and a couple of others, it would still take a very freaking long time. So if you're an XRP holder, at least for right now, they've not even filed the appeal. It will most likely get denied. We don't know anything about the timelines just quite yet. We haven't seen Ripple's response because that's another part of it all. And even if, it will still take a long time before anything could be changed. I'm seeing a lot of people in my comment section say, they got denied already, they got denied. They didn't. Some people, I'm just reading comments right now. Some people say, hey, don't FUD. It's got nothing to do with XRP being a security. That's my thought process. Again, if you want to know exactly what this is about, these guys are trying anything they can to make sure they get more of a win over Ripple. And it doesn't matter how low they have to stoop or whatever to get it. Eleanor Tourette said, from everything I've learned about intellectual appeals from the brilliant legal minds in the space, they are notoriously tricky to get approved, all right? And that's to get it approved. The SEC will need to get blessings from both Judge Torres and the Second Circuit in order for this to be granted. And again, Judge Torres has not been very friendly with the SEC all the while. CryptoWolf also says that, so it's looking, yeah. Also, guys, just so we're all in the clear, the deadline for Ripple, they're going to file it next week. They just said it, they're going to file it next week. The deadline, strangely enough, it says right here, it's 2 days after the defendant's response. Oh, wait a minute, I'm actually a little bit stupid. The SEC files its opening brief on August 18th, which is 2 days after the defendant's response to this letter is due, which again is in 6 days from now, the 16th. And I'm guessing, no, I'm just checking it out. They've got between Monday and Wednesday. Ripple's been pretty quick with it recently, but let's just see if it's going to be Monday, Tuesday, or Wednesday. And the rest of the order is just written down here if you want to read more into it, but it's just further scheduling. Crypto Law themselves said in this letter, the SEC says it intends to seek intellectual appeal on Judge Torres' ruling the defendant's programmatic sales and other sales of XRP failed the Howey test for being securities transactions. The judge and the Second Circuit will both have to agree with the SEC's arguments for why an intellectual appeal should be allowed before the trial on aiding and abetting by Brad Garlinghouse and Chris Larsen. So that again is another part of it all. It needs to also be, thumbed up that it needs to happen right now before the case is over. And the remedies phase of the ruling on institutional sales. And this has to do with the idea that the remedies phase, because this has to happen before anything, could take years. If the intellectual appeal request from the SEC is ultimately not granted, then the SEC will have to wait until after the trial and remedies phase, which could take years on its own because there needs to be a lot of due diligence done to attempt its appeal. And that again means that their appeal itself has not been denied just quite yet, because that would rule everything out. But that means that they are not allowed to file for an appeal, which means they can try to file for it again later after the case is over. Again, Ripple will actually respond to this before the judge and Second Circuit make their responses. And another clarification, and this one is really, really important. They will only consider, as of this point, right, whether or not the intellectual appeal itself is legally warranted. So that means that there should be an allowance to file for it now, not the merits of an appeal itself. These are different things. So we're not talking about the internal pieces of the appeal as to why, why, yeah, I don't even have to explain this here. It's two different pieces, and they're basically going to, the Second Circuit and the judge are going to discuss with themselves whether or not the SEC should be allowed to file the appeal now, or whether or not they should have to wait till the future, basically. Not about whether or not they should be allowed to appeal at all, or about the appeal itself, because that will be discussed later, basically. Because at the end of the day, I believe you can always appeal at the end. I'm not 1,000% sure on that. What I do know, though, is that that's what it's about. Whether or not an intellectual appeal is appropriate in the middle of things. The SEC said they need to do this before the rest because they have so many cases pending. I should also add another couple of clarifications. Crypto Law said fact check on the pre-trial scheduling issued earlier today by Judge Torres. Ripple is not going to trial. That's important. Ripple is, with the lawsuit part mostly done for. It's about Brad Garlinghouse and Chris Larsen. The Judge Torres' ruling that XRP token is not a security is not going to trial. The trial will not decide matters of law, only one narrow set of facts in dispute, which is again aiding and abetting. The remaining dispute over the facts relating only to Chris Larsen and Brad Garlinghouse were explained on pages 30 to 34 of the decision. And it's again about aiding and abetting. And again, a lot of these stuff is pretty confusing. And also, guys, I'm not a legal expert, right? I like finance. I like, but the legal part and all this is pretty important. And I think as of this point, for a non-lawyer, we do know a lot about it because we've been reading this for freaking years. But Darren asked a couple of questions about, the actual semantics of things, I guess, with regards to final ruling and things like that. Again, the judge herself has made all the rulings that we wanted. All that's happening is that some pieces are being sent forward to a jury to decide with regards to facts of aiding and abetting. The judge has made a decision that's over and done with, and some parts of that the SEC is not agreeing with, and they want to make sure it gets appealed. But I also want to make clear, XRP right now, as we speak, it's not a security. Oh, wow, what if the SEC's appeal gets approved? That does not mean it's a security. Not at all right? The SEC is going to then, once the appeal is allowed, the SEC is then going to be allowed to explain why they do think the judge made a mistake or why it needs to be looked over again. They're going to quote all these different left and right sources, and it's only after that that things could change for some parts. Right now, nothing's changing. They just filed for an appeal. They didn't appeal just quite yet, didn't get granted. I just want to make sure everything is really, really clear. Anyway, from reading more and more and more, and I can sometimes get stuck in this little phase where you just get stuck on Twitter reading more and more and more. I should call it X now, shouldn't I? Yeah, but you get stuck and you don't necessarily learn anything new, just keep reciting the same facts from different people. Conclusion is, from what I'm seeing on the interwebs, people all expect the SEC to not even get this one granted. And it's just them grasping at straws, trying anything in their possible realm. Trust me when I say that many people are going to get this wrong, all right? And generally speaking, the crypto community is saying, hey, good luck, SEC, because you're not going to get it. But also, I think I got to describe one thing more, again, reasonably here. The whole distinction here should be made in the sense that the appeal is with regards to how Ripple sold XRP at some points in the past. Ripple's trying to argue, this is critical, that a lot of their sales were not security transfers. If they sold XRP over an exchange, not a transfer of a security, not a securities transaction, not an investment contract of sorts, anything along those lines. The SEC is saying, well, and again, they're not arguing XRP itself as a security. They aren't arguing that you selling to your friend XRP or transacting that is a security. They're saying Ripple, as a company, selling XRP over exchanges are investment contracts still. Even though we don't know who bought it, even though we don't know. But again, I personally believe if they do get granted this intellectual appeal, that would only mean it gets shifted from at the end to right now. But then the moment that they do get it granted, if the urgency is there, they'll still not win because the judge made it pretty clear that there's nothing really to look over anymore. She cited different cases. Oh, but different judges, different opinions. It doesn't matter. The judge was very clear by saying that if you sell your crypto over an exchange, it's literally impossible to prove that that person had an expectation of profit from you because the person buying didn't know who they're buying from, and theoretically speaking, the person selling didn't know who they're selling to. So let's say we have a transaction between party A and B. How could party B expect profits from party A when they don't know who party A is? Ripple could have sold to my grandma, and my grandma doesn't know about Ripple. Was that an investment contract? Did my grandma expect profits from Ripple? No. So in theory, what the SEC could say is, okay, if Ripple knew they were selling it over an exchange to one specific party, or if they were selling it in some others, because they're also trying to allege that Ripple paying out XRP to some other parties like developers or whatever is also investment contracts. How does that make sense? But again, they're not saying XRP itself is security. They can't try to claim that. They're trying to get more sales from Ripple's side to be deemed as investment contracts. That's what the appeal is about. I have to reiterate again, it's not approved just quite yet, but that's what they're trying to get. And once that's approved, I still think the SEC will, the judge will deny the contents of the appeal. But right now, the only issue at hand is being able to actually file the appeal early. Anyway, guys, like I always say, make sure you go ahead and put that notification bell on so you never miss out. Because what if something crazy happens? You want to be notified is what I always say. And I always try to be there with the quickest, best reported news. So, make sure you got the notification bell so you don't miss out. And that's about it. See ya.